For years, American lawyer Stephen Donziger and his team attempted to publicly pressure Chevron and force the company to settle the lawsuit in Ecuador. They believed they could take Chevron's reputation hostage and ransom it back to the company. They were wrong. Chevron fought back against a scheme the Wall Street Journal recently called the legal fraud of the century. The company was confident that Donziger and his team had no evidence to support their claims and procured the judgment in Ecuador through fraudulent means. Chevron filed a federal lawsuit against Donziger and his associates in 2011, and on March 4, 2014, the company was vindicated when the U.S. District Court for the Southern District of New York ruled in a nearly 500-page opinion that the $9.5 billion Ecuadorian judgment against Chevron was the product of fraud, finding it unenforceable in the United States. The ruling found that Donziger violated the Federal Racketeer Influenced and Corrupt Organizations Act, committing acts of extortion, money laundering, wire fraud, Foreign Corrupt Practices Act violations, witness tampering, and obstruction of justice in obtaining the Ecuadorian judgment. During the 7-week trial, Chevron presented unrebutted evidence detailing the extent of the fraudulent acts undertaken and directed by Donziger, his Ecuadorian legal team, and other associates. 17 former insiders and allies testified against Donziger's scheme, including his former co-counsel, environmental consultants, employees, and his Ecuadorian collaborators. Chevron proved that Donziger and his team fabricated environmental evidence, pressured scientific experts to falsify reports, plotted to intimidate judges into handing down favorable rulings, bribed a court-appointed expert, ghost-wrote court reports, and even drafted the final judgment. Presiding Judge Louis Kaplan stated in his ruling, "The decision in the Lago Agrio case was obtained by corrupt means. The defendants here may not be allowed to benefit from that in any way." The court found that Donziger and his team wrote the Ecuadorian court's judgment themselves and promised $500,000 to the Ecuadorian judge to rule in their favor and sign their judgment. The judgment went on to say, the wrongful actions of Donziger and his Ecuadorian legal team would be offensive to the laws of any nation that aspires to the rule of law, including Ecuador, and they knew it. Donziger and his team had to resort to fraud because they had no scientific evidence to support their claims. And just 2 months after the verdict, the fraudulent Ecuadorian scheme suffered another blow when the Washington, D.C. law firm Patton Boggs withdrew from the lawsuit, agreeing to pay Chevron $15 million and issuing a statement saying, based on the court's findings, Patton Boggs regrets its involvement in this matter. Before leaving Ecuador in the 1990s, Texaco reached an agreement with the government to remediate a number of oil production sites in proportion to Texaco Petroleum's minority ownership share. Texaco worked with well-respected international third parties on remediation and community improvement programs, which the government of Ecuador and local community leaders reviewed and approved. Texaco made approximately $500 million during its time in the consortium. During that same period, the Republic of Ecuador received nearly $24 billion in royalties, profits, and taxes. In the 22 years since Texaco Petroleum ended its operations in Ecuador, the government of Ecuador and its state-owned oil company, Petroecuador, have continued and expanded oil production in the former consortium area. In fact, the government has previously admitted that it is responsible for all further remediation in the area. It is now Chevron's sincere hope that the government of Ecuador will live up to its responsibility and address the issues facing the people of the Amazon region. The conspirators who have long perpetrated the Ecuador litigation fraud are shameless, and they are tenacious. But Chevron is confident that this judgment signifies the beginning of the end of their scheme. While this ruling prohibits Donziger from enforcing and profiting from his scheme in the United States, the plaintiffs continue to try to advance the enforcement of their fraudulent judgment in Canada, Brazil, and Argentina. Chevron is committed to continue aggressively defending the company and its shareholders from this attempted extortion, and believes that any jurisdiction that respects the rule of law will find the Ecuadorian judgment illegitimate and unenforceable.